Good morning. My name is Ruth Youn. I'm an Education Policy Research Fellow. I'm also a constituent of District 45. So I'm happy to be here this morning. This organization is an independent, nonpartisan nonprofit, and we work to achieve educational equal educational opportunity for every child through strong public schools. We do support the spirit and intentions of this bill to provide policies for filtering pornographic material from school-issued devices. However, we actually oppose this bill in its current form because it leaves certain diverse content susceptible to censorship. It mandates unnecessary surveillance and threatens student privacy protections, which are stated in federal law. So HB 338's definition of material that is harmful to minors leaves diverse websites and resources, especially those addressing LGBTQ plus topics, susceptible to being incorrectly censored. LGBTQ plus students may need to use school-issued devices for information about this aspect of their identity or medical information. For example, they may not have access to internet at home or live in environments where they are at risk of physical or emotional harm if seen accessing such content. Additionally, this bill requires that computer software and non-experts analyze and block obscene material. Conventionally, this kind of analysis is called a Miller test, which is performed in a court of law by legal experts. However, this bill puts the responsibility of nuanced legal analysis and determination in the hands of artificial intelligence and potentially local school board members. Without requiring training or explicitly stating that LGBTQ plus materials are not inherently obscene, we risk censoring this material. Schools have been already required to use software programs designed to block access to harmful materials, but this particular bill redefines protection measures as inspecting and analyzing encrypted and unencrypted internet traffic. Rather than filtering, this is active surveillance of not only students, but staff and caregivers' internet traffic. It mandates the pursuit of personal information through data collection without parameters on what data is collected and who has access to them. Therefore, this puts children's privacy at risk and is a violation of federal law according to the Children's Online Privacy Protection Rule. There are no standards right now for reporting requirements for vendors regarding the type of data elements that will be collected, who has access, what parameters they will be deemed as harmful, and no standards on how they are stored or if they are ever destroyed. Thus, we are also at risk for violating FERPA, the Family Education Rights and Privacy Act. So Georgia leaders, please take responsibility to ensure that the privacy rights of students are protected. Mandating surveillance and omitting accountability measures for data collection and reporting is tantamount to spying, and in this case, spying on children and on school employees and caregivers. We urge the committee to oppose HB 338 because it does not protect students. Rather, it risks censoring legitimate resources, violates student privacies, and allows vendors to collect information without transparency or accountability. Thank you.
Thank you so much. You've got one question. Senator Dolezal.
Thank you for being here, and thank you for taking the time to come and share with us your thoughts on this topic. You referenced the Miller test, which is in line 92 of the bill, which I think we all know what that is. But then 93 of the bill has and. The material depicts or describes in a patently offensive way sexual conduct as follows, and it enumerates 5 things as it relates to what sexual conduct is. I'm curious which of those you believe students should have access to on school computers. Is it the act of sexual intercourse, heterosexual or homosexual, normal or perverted, actual or simulated? Is it acts of masturbation, acts of excretory functions or lewd exhibit of the genitals, acts of bestiality or the fondling of sex organs of animals, or sexual acts of flagellation, torture, or other violence indicating a sadomasochistic sexual relationship? Which of those 5, in conjunction with the Miller test, I think are pretty well spelled out here, do you have concerns with students not being able to access?
The Miller test is a 3-pronged process that evaluates content, and it is done by legal experts.
I'm asking you about this section.
I am not a legal expert. However, I would say that we support putting filters on to block harmful material. The question is, what is harmful material? Is it legitimate medical information? Is it information on how LGBTQ plus students can avoid being bullied? What their rights are if they're being discriminated against? These have nothing to do with explicit material that no child needs access to.
Right, but none of those are in the bill. So the question that I asked you is, of the 5 things I just told you that are spelled out in the bill, they're the secondary requirement to the Miller test. So throw the Miller test out for a second, because it has to meet both criteria in order to be prohibited from being accessed.
Sure.
I don't see any of those that actually relate to your concerns. So I'm curious what you see there.
Right. And that question actually sidesteps what is really of concern here, which is the data collection part. No one is addressing how this data is collected, where it's reported, who's keeping it, and who's evaluating it.
My question doesn't, it's impossible for a question to sidestep something. My question is it relates to your testimony. You began your testimony by saying this would prevent access to, I believe, what you called a, quote, diverse website. I just gave you 5 categories of things that will be prohibited from being accessed. And I'll ask you the question for a third time.
Mm-hmm.
Which of those 5 things do you believe students should have access to on school computers, tablets, etc.?
I will let legal experts make that determination. Thank you.
Thank you.
Mr. Chairman, can I respond to?
Oh, absolutely.
Let's stay focused on grade appropriate material. It's an educator's and a system's responsibility